We'll hear argument next to number 95-1858, Dennis C. Vacco, Attorney General of New York, versus Timothy E. Quill.
Mr. Chief Justice, and may it please the Court, the question in this case is whether the state must remain neutral in the face of a decision of one of its citizens to help another kill herself. The Second Circuit below said yes, as a matter of equal protection. It is New York's view, however, that the Constitution does not require this to be the case. Indeed, equal protection is not implicated at all in this case. But the notion of sedation, as recognized by the vast majority of the medical professionals, is a notion of sedation in the imminently dying, when individuals are actually in the last hours of death. Sedation is for the purpose of treating four distinct symptoms: nausea, shortness of breath, delirium, and excruciating pain. And only when these symptoms are tractable.
A correct use of the word sedation? It seems to me you're talking about analgesics, painkillers, whereas sedation is just to kind of make you feel better, not mind things so much, isn't it?
Mr. Chief Justice, as the medical professionals have written in their briefs, and even the articles that are alluded to in the various briefs will indicate, that the medication that is provided in these limited circumstances is provided only for the very limited effort to control those four symptoms that
yes, my only question is whether it's properly called sedation or not.
In New York, as in most states, it's a crime to assist a suicide, but patients are allowed to refuse unwanted medical treatment, even if that treatment is necessary to save their lives. The question presented in this case is whether this distinction is so irrational that it violates the Equal Protection Clause of the 14th Amendment. The respondents here are New York doctors, and they argue that refusing life-sustaining medical treatment is really the same thing as physician-assisted suicide. And so it does violate the Equal Protection Clause to permit one but not the other. The District Court rejected this argument, but the Court of Appeals for the Second Circuit agreed with it. Under the Equal Protection Clause, states must treat like cases alike, but may treat unlike cases accordingly. That's the proposition which we have followed for a long time and follow here, and we therefore reverse the judgment of the Court of Appeals. The respondents, as I've said, contend that some terminally ill people, those who are on life support treatments systems, are treated differently than those who are not, because the former may hasten death by ending treatment, but the latter may not hasten death through physician-assisted suicide. This argument assumes, though, that ending life-saving treatment is the same thing as assisted suicide, and we reject this assumption. The distinction between assisting suicide and ending life-sustaining treatment is widely recognized and endorsed in the medical profession and in our legal traditions. In our opinion, we focus primarily on two important differences between the two practices. First, a patient who commits physician-assisted suicide is killed by the lethal drug provided by the doctor. But when a patient refuses life-sustaining medical treatment, he dies from his underlying disease or condition. Second, a physician who honors a patient's request to end unwanted treatment does not necessarily intend that the patient die. He may only intend to respect his patient's wishes and to cease doing futile or degrading things to the patient. On the other hand, a doctor who assists a suicide must necessarily intend primarily that the patient be made dead. The law has long distinguished between actions taken because of a given result from actions taken in spite of their intended but unforeseen consequences. It's therefore not surprising that many courts, including this court in our recent Cruzan opinion, and the overwhelming majority of legislatures, have drawn a clear line between assisting suicide and ending unwanted treatment. We therefore reject respondents claim that the distinction between the two is irrational or arbitrary. Logic and contemporary practice support New York's judgment that the two acts are different, and the Constitution permits New York to treat them differently. Justice O'Connor has filed a concurring opinion which Justices Ginsburg and Breyer join in part. Justices Stevens, Souter, and Ginsburg and Breyer have filed opinions concurring in the judgment.